Yes, madam. Your turn.
Item 33, Second Appeal 367 of 2018.
Lordship. This is my lord, the defendant's second appeal against the judgment of affirmance. Now, lordship may kindly see, my lord, that the plaintiff, my lord, filed title partition suit number 16 of 2003, claiming partition of Schedule A property, my lord, and for carving out separate takta with respect to the lands of Khata number 201 and 202 situated at village Devipur in the district of Kodarma. Suit filed by the plaintiff was partly decreed, holding that the plaintiff is entitled to get half share in the suit property except the land which has already been sold by the grandfather of the plaintiff under Khata number 101 and 102.
101 or 201?
I am sorry, my lord, 201 and 202. Now, lordship may kindly see, Bhiko Mahato, my lord, was the common ancestor of the party. Bhiko Mahato, my lord, dad leaving behind two sons, Lekho and Bishu. Lekho, my lord, dad leaving behind Kameshwar, who is the plaintiff, and Bishun Mahato, my lord, dad leaving behind Kishun Mahato and Ramdev Mahato. Bishun is defendant number 1 and Kishun Mahato is defendant number 2 and Ramdev Mahato is defendant number 3.
Kishun and Ramdev.
Kishun and Ramdev. They are
the plaintiff, defendants.
lordship, sons of Bishun.
And Bishun is also a party.
Bishun, yes, lordship, defendant number 1.
1 is Bishun, 2 is Kishun, and 3 is Ramdev.
Lordship.
Okay.
Now, my lord, the case of the plaintiff as set out in the plaint.
No, what is the substantial question of law? There are concurrent
Lordship may kindly see. Substantial question. Only one substantial question of law.
Yes. Which is that?
Lordship may kindly see page 9. Page 9, my lord,
Yes.
of the memo of appeal. B. Whether the findings of the learned courts below on issue of devious partition is perverse on the face of exhibit G.
नहीं ये तो नहीं है कौन सा आपका कौन सा सब्सटेंशियल क्वेश्चन
ये मेमो ऑफ अपील का पेज नंबर 9 देखा जाएगा सर
9 में क्वेश्चन ऑफ लॉ नंबर
सब्सटेंशियल क्वेश्चन ऑफ लॉ बी लॉर्डशिप whether the finding of learned courts below on issue of previous partition is perverse on the face of exhibit G, that is memorandum of partition and admission of PW 6 made in para 13 and 20 of the cross examination. Now, lordship may kindly see exhibit G, my lord, is memorandum of partition which has been exhibited without objection. Lordship may kindly see.
yes
This is my lord.
what is the date
Exhibit G,
date
80, date of memorandum of partition,
yes
15/1/1983. In which, my lord, signature of the plaintiff is also appearing. Lordship may kindly see the memorandum of partition, and there is a specific pleading in the written statement filed by the defendant number 1 that the suit property was previously partitioned Lordship may kindly see, and this document has not been considered by the learned trial court as well as the first appellate court.
Where is the finding of the learned trial
Lordship
court on
may
the
kindly
previous
see.
partition?
Yes. Lordship may kindly see trial court judgment, my lord, internal page 8,
Internal page 9.
running page 6,
Internal page 9.
internal page 8, lord.
Internal page 9 also. That is the
9
finding.
also, 9 also. 8,
That is the case of the.
third line from the bottom, lordship.
You just come to para number 18.
80, yes. Having gone through the above discussion, I find that no partition held in the year 1980, nor memorandum of partition prepared in the year 1983 by both parties, because if there was existence of memorandum of partition in between the parties, then the defendant might have incorporated it in his WS file in the year 2004. Also, signature of plaintiff on deposition does not match it with the signature of plaintiff on memorandum of partition by Exhibit G. Nowhere plaintiff Kameshwar Yadav has admitted his signature in memorandum of partition. The plaintiff has not denied his signature. Rather, my lord, it has been exhibited without objection. And lordship may kindly see, there is a specific pleading in the written statement that partition took place in the year 1980. And
There were two written statements filed.
yes, two written.
Why was it not mentioned in the year 2004?
Earlier written statement it was mentioned that the suit property was previously partitioned.
In 2004 it is
Four.
statement.
Yes, lordship.
Where is that?
Lordship may kindly. Lordship may kindly see para 5. There is a specific pleading.
Para number?
5, lordship. 5, first page. Suit is bad on account of previous partition.
There is no such pleading. This is not
And
a-
lordship may kindly see the another
this is
written.
hardly a pleading.
Lordship may kindly see the another written statement.
That is a subsequent.
That
written
is on
statement.
the record, which has been accepted by the court, lordship.
That's right.
Which has been accepted
What
by
was
the
the
court.
occasion to file other written statement?
Another written statement was filed, my lord, elaborating, my lord.
On
the-
account of some amendment.
No.
Why was it filed?
Additional written statement was filed on behalf of the defendant
Additional तो
number
तभी
1.
ना होता है सर जब
जी।
कोई amendment allow होता है.
Amendment का हम कहीं
ऐसा
provision
कैसे
है,
additional?
order 8 rule 9 में जो provision है additional written statement का, and it has been accepted by the court. It has not been challenged by the plaintiff. It has been accepted by the court, and there is a specific pleading that partition took place in the year 1980, and accordingly memorandum of partition was prepared, which is Exhibit G, and the said document has been exhibited without any objection. Lordship may kindly see, which is, my lord, bone of contention that the suit property was previously partitioned.
Apart from this document, memorandum of partition, is there any evidence that parties were dealing with the property separately and there was mutation pursuant to that agreement?
Lordship may kindly see.
Is there any finding to that effect?
Lordship may kindly see
Yes.
the evidence of the plaintiff.
Mutation entries were made in individual name. Is there any finding to that effect?
No.
Then
They-
it is of no use.
Lordship,
Then it is of no use.
if the property was previously partitioned and
See.
accordingly, my lord, memorandum of partition was prepared and the same was given effect to.
How? What is the mode of giving effect?
The signature of plaintiff is appearing.
That is not giving effect to the partition. That is the partition itself. You see, the
And the-
memorandum of partition can be relied upon right? When the parties they separate themselves, they are dealing with the property
The
separately.
plaintiff-
Mutation is already
The
taken
plaintiff
place.
has sold the property. It has come, Lordship, that the plaintiff has sold the property which was allocated in his share.
Where is that?
Lordship.
And by which deed he
Yes.
sold it?
Lordship, may kindly see the earlier written statement. Which
What
was
is the deed and what is the exhibit number? Show me the exhibit.
Lordship, may kindly see the statement, Lordship.
No, why should I see the statement?
Statement.
I want to know. You say that he has sold it. Show me the registered deed.
Exhibit A series, my lord, is the sale deed. Lordship, may kindly see, my lord, exhibit A series.
Exhibit A series.
Yes. And Lordship, may kindly see the statement made in the written statement. Original written statement, Lordship.
Exhibit A1 is the deed executed by Bhikkhu Mehto. That is a grandfather.
Grandfather.
Correct? So it is of no relevance so far as this aspect is concerned. Exhibit A is also Bhikkhu Mehto. Exhibit A1 is also Bhikkhu Mehto. Exhibit A2 is of the year 1949. Exhibit A3 is of the year 1947. Exhibit A4 is again executed by Bhikkhu Mehto. Correct? The common in the name of Bigan Singh. Right?
Because this property was allotted, my lord, this property was allotted to Biganma. This is the specific statement, Lordship, may kindly see in the written statement.
Bigan Mehto. Who is Bigan Mehto? In this particular genealogy that you have given, there is no name of Bigan Mehto. There is Kameshwar, Lekho, Bishun, Bhikkhu, Kishun and Ramdev.
Lekho and Bishu, they are, my lord,
Lekho
sons
and
of
Bishun. Bishun.
Lordship, they are
Bhikki
sons of
Mehto?
Bhikkhu.
Bhikki is something. Bhikko. Bhikko is a common ancestor. If the common
Bhikko.
ancestor is
Bhikko.
selling the property, then that does not mean that there is a previous partition.
Lordship, may kindly see the statement made in the original witness. One line, Lordship. That Bhikki Mahato in the year 1980, I am reading, my lord, the original witness. That Bhikki Mahato in the year 1980, and the demand of the plaintiff partitioned the lands of Khata number 36 and 21 of village Usmai, which is not the subject matter of the suit property, and the land of Khata number 201 of village Devipur, which is the subject matter of the suit property, by meets and bounds. The plaintiff Kameshwar Yadav insisted that he be allotted the lands of Khata number 36 and 21 of village Kusmai, and Bisun Yadav be allotted the land of Khata number 201 of village Devipur, which is not the subject matter of the suit property. At the time of partition, number of family members of Bisun and Kameshwar Yadav were taken into consideration. The plaintiff Kameshwar Yadav, having very small family without any male issue, gladly accepted the land of Khata number 36 and 21 of village Kusmai, which he was allotted to him in partition, and was in possession of the same. The lands of Khata number 201 of village Devipur, which are of interior and less valuable, have been allotted to Bisun Mato, who is coming in continuous possession of the said land, except the lands sold to Pulmati Devi. The memorandum of partition was prepared in the year 1983. It has been amended, Lordship may kindly see.
That's right.
Amendment
You
has...
said that the plaintiff had sold the property allocated to him. I'm looking for that statement.
Yes, plaintiff has sold the property.
Where is that statement? That the property has sold the property allocated to him in memorandum of partition. Which is that statement?
This is the statement of
No,
in para
plaintiff
90.
has sold. Plaintiff is Bishun, Kishun and Ram.
No, Lordship.
They are the defendants. Kameshwar.
Plaintiff is Kameshwar.
Which deed has been executed by plaintiff as per the written statement? And kindly read that written statement and give me the date and date of the deed also. Which deed is that?
Lordship, this has not been denied. Lordship, there is
There has to be. You have many were saying that the plaintiff has sold the property allocated to him.
Yes.
By a registered deed.
Yes.
I am asking you which is that deed? Which has been executed by the plaintiff? And what is the date of that deed? When you say that it has been sold, I will ask you the date of the deed, no?
There is a specific pleading, Lordship may kindly see. Para 24, Lordship. That after partition, the plaintiff was in possession of the land of village Kusmai and dealing with the same. He had absolutely no concern on any right, title, interest or possession over this property.
That's it. But you said that the property allocated to the plaintiff was sold by the plaintiff.
Yes.
Dealing with it means what?
Lordship,
A person is dealing with the property while in possession.
Lordship, it has come, Lordship, in memorandum of partition. Lordship may kindly see the contents of the memorandum of partition.
I will not see
Which is Milord exhibited without objection. This is a strong piece of evidence, Lordship, to show that the suit land was previously partitioned. And this has not been taken into consideration, although there is a specific pleading in the written statement that partition took place in the year 1980 and accordingly memorandum of partition was prepared in the year 1983. Lordship may kindly see the contents of the memorandum of partition. And the plaintiff has not denied the memorandum of partition.
What is the finding of the learned appellate court on the point of
Lordship.
exhibit G?
Lordship.
You read para 27. Para 27, page number 20.
Lordship, can you see below internal?
Internal page 20, para 27.
The defendants have filed a memorandum of partition dated 15/1/1983, Exhibit G. I perused the Exhibit G and found that it is written on plain paper, on which signature of Kameshwar Yadav and Vishnu Mahato as well as signature of the witnesses Balaram, Rajkumar Singh, Sarju Mahato, Baleshwar Yadav, Shiv Kumar Yadav, Bhuneshwar Yadav are shown without date. And the maker of the deed is one Somar Singh. However, his signature is missing there. It is pertinent to note that in the WS of the deceased defendant number 1, who is the son of the common ancestor, initially the plea regarding memorandum of partition was not taken. This is, my lord, an error of record. Lordship mechanism.
No, previous partition, initially the plea of previous partition by giving these details has not
No,
been
details.
mentioned.
Lordship,
Details have not been given in the initial.
I will show you.
That there was a partition in 1983.
Yes, I will
Show me.
नहीं होगा उसको
2004 वाला दिखाई. 2004 वाला रिटन स्टेटमेंट दिखाइए कि 1983 को मेमोरेंडम ऑफ पार्टीशन बना था और 1980 को पार्टीशन हुआ. दिखाइए सर.
हुजूर जो बोल रहे थे बाय वे ऑफ अमेंडमेंट.
ये अमेंडमेंट है.
देखिए
अमेंडमेंट नहीं है सर, ये अमेंडमेंट नहीं है. उनके डेथ के बाद
नहीं ये देखा जाए ना हुजूर स्पेसिफिक है कि नहीं. ये ओरिजिनल रिटन स्टेटमेंट. This is the original written statement filed by the defendant.
when did the defendant number 1 die? What is the date of death of defendant number 1? after the death of defendant number 1, they amended the plaint and they filed a written statement additionally. This is all discussed in the appellate court's judgment.
Lordship,
How this factors come into
the written statement.
and the
The written
appellate
statement was filed in the year 2004.
yes, amended in the year
The original
2011.
written statement was filed in the year 2004.
Amended in the year 2011.
Amended in the year 2011, which relates back not from the date of the institution of this.
That's right.
This is the law.
Okay. I've heard you enough. Now you listen to the judgment.
And Lordship may kindly see, my Lord, the legal heirs of the defendant number 1, they have been substituted in the year 2013. Lordship, 2013 they have been substituted.
In 2013.
13. An amendment, Lordship may kindly see. Prior to, my Lord, the substitution of the defendant number 1. Lordship may kindly see. This is, my Lord, the certified copy. This is not the case, my Lord, that
So this has been amended and the daughters have been made party. They have been added as party. They are not. This is not substitution. This is addition of party.
Lordship, they have been substituted
No.
after the death.
This is not substitution. This is addition of party. Daughters are being put on record.
No.
You just read this paragraph. Para number 27 आप पढ़िए.
हाँ.
ये para 27 आप पूरा पढ़ लीजिए. और इसमें कौन-कौन सा गलत है बताइए. जहाँ गलती लिखा है ना appellate court ने, बस वहाँ pause करके you just indicate that this is an error of record.
It is pertinent to note that in the WS of the deceased defendant number 1, who is son of the common ancestor, initially the plea regarding memorandum of partition was not taken. However, after the death of original defendant number 1, when his wife and 2 daughters became the party as substituted defendants, the wife of the deceased defendant number 1 for the first time taken the plea in her witness statement that the suit is bad for previous partition between Kameshwar Yadav and Vishnu Yadav, the original defendant number 1 in the year 1983, in presence of respectable persons of the village, and prior to it, it was pleading of the defendant that the suit land was orally partitioned. This is, my Lord, the defense taken by the defendant in the original written statement. That is.
सर आप हमको सिर्फ इतना बताइए इस पर्टिकुलर डिस्कशन में पूरे पैराग्राफ में which line suffers from error of record?
This is, my Lord, it was pleading of the defendant that the suit land was orally partitioned. There is a specific pleading, Lordship may kindly see, that the suit land was previously partitioned.
That's right.
And thereafter memorandum of partition was filed, which has been exhibited, which would go to show that the suit property was previously partitioned, which has been disbelieved by both the courts.
आगे बढ़िए. Please read further.
It was pleading of the defendant that the suit land was originally partitioned during the lifetime of common ancestor in the year 1980. However, defendant number 1 and 2 who had filed a joint WS with the deceased defendant number 1 and the substituted defendant amended their pleading by order dated 7/7/11 after about 8 years of the filing of the suit. Now, my Lord,
आगे बढ़िए.
if amendment has been made, that has not been challenged by filing appeal or otherwise, and they introduced the pleading that a memorandum of partition was prepared in the year 1983. It is relevant to mention here that the original defendant number 1, who is signatory of memorandum of partition, his deposition has not
In his deposition has not
stated anything about the same. Rather, at para 38 of the cross-examination, he admitted that he cannot produce any paper regarding partition of the suit land.
आगे बढ़िए.
The defendants have failed to explain as to why such important document was withheld by the original defendant number 1, whereas it has come in the evidence that after the death of the common ancestor, he became the karta of the family, and as per the defendant's case, the memorandum of partition was executed in his presence. Furthermore, the plaintiff, who is also shown as one of the signatories of the memorandum of partition, was not confronted with the said memorandum of partition during his cross-examination, and he was not asked to admit or deny his signature on it. The defendants have not produced the maker / scribe of the memorandum of partition as witness in this case, whereas the memorandum of partition suggests that one Somar Singh was the scribe of the memorandum of partition and the defendants have put their signature in his presence. It is quite surprising, and for the reason best known to the defendant, the signature of the scribe of the memorandum of partition is not present. Although the defendant had examined one of the witnesses of the memorandum of partition, DT.12.01.2026, who has proved his signature, but in the totality of the circumstance, no reliance can be placed on memorandum of partition. Therefore, my lord, the finding of the learned first appellate court is perverse on account of non-consideration of Exhibit G, which is, my lord, a document of partition, in which, my lord, it has been specifically mentioned that the suit property beside other properties were partitioned in the year 1980 and thereafter memorandum of partition was prepared in the year 1983. So, my lord, non-consideration of Exhibit G, my lord, itself is a substantial question.
Essay number 367 of 2018, heard the learned counsel appearing on behalf of the appellant. This appeal has been filed against the judgment in decree dated 25/7/2018 within bracket decree signed on 3/8/2018 bracket close passed in civil appeal number 10 of 2013 within bracket title appeal number 10 of 2013 bracket close passed by learned District Judge Roman II Kotarma, confirming the judgment and decree dated 28/2/2013 within bracket decree signed on 8/3/2013 bracket close passed in partition suit number 16 of 2003. The learned counsel for the appellant has submitted that the suit was for partition and was numbered as title partition suit number 16 of 2003. The suit was partly decreed in favor of the plaintiff and was dismissed with respect to the schedule of the with respect to a portion of the suit property which was already sold by the grandfather of the plaintiff, namely Bhikkhu Mehto, the common ancestor, under Khata number 201 and 202. The learned counsel has submitted that the suit was filed seeking partition of Khata number 201 and 202 in village Devipur, district Kotarma. By giving the genealogy, the learned counsel has submitted that Bhikkhu Mehto was the common ancestor who had two sons, Lekho Mehto and Bishu Mehto. Lekho Mehto had one son, namely Kameshwar Mehto, who was the plaintiff, within bracket Kameshwar Yadav, who was the plaintiff in the case. And so far as Bishu Mehto is concerned, he had two sons, namely Kishore Mehto and Ramdev Mehto. Bishu Mehto, Kishore Mehto and Ramdev Mehto were the defendants in the case and were defendant number 1, 2 and 3 respectively. The learned counsel submits that the judgment passed by both the learned courts is perverse inasmuch as the memorandum of partition exhibit G has not been considered. Has not been properly considered. The Learned Counsel has referred to the proposed substantial question of law, number B, which is quoted as under. He submits that the appeal be admitted on the aforesaid substantial question of law and notice be issued. The Learned Counsel has also submitted that the plaint was amended in the year 2011 and therefore the principle of relate back with respect to the pleadings would apply, and the learned court has failed to properly appreciate the pleadings and the evidences based on record. After hearing the learned counsel for the appellant, this court finds that the plaintiff had filed the suit for partition, claiming half share in Schedule A property. The genealogy तो dispute में नहीं है ना? The counsel for the appellant has also submitted that the genealogy pointed out as above is not in dispute. The specific case of the plaintiff was that one Vicky Mehto was the common ancestor of both the parties. And mentioned that Khata number 201 and 202 were having different plots and was the ancestral property of say Vicky Mehto, and rest were acquired by the plaintiff. It was stated that Vicky Mehto died about 22 years ago, leaving behind him his two sons, Bishun Yadav and Lekhu Yadav, who jointly succeeded Vicky Mehto and came in joint possession of the school property. Lekhu Mehto died leaving behind one son, namely Kameshwar Yadav. Similarly, Vishnu Mehto died leaving behind his two sons, Vishnudev Mehto and Ram Narayan Mehto. It was the case that plaintiff's father Lekhu Mehto died just after death of Vicky Mehto in a state of jointness, which is brother Vishnu Mehto, who was defendant number 1. It was further stated that the plaintiff was minor and defendant Vishnu Yadav became the karta of the family and was managing the family properties. The plaintiff demanded in spite of demand by the plaintiff, the defendant was not furnishing the accounts of the produce of the suit land, and ultimately when the plaintiff demanded partition, the defendant denied the same. The defendants appeared and filed a written statement stating that the suit was bad for previous partition, misjointer and non-jointer of necessary parties, etc. It was asserted that Khata number 201 was the self-acquired property of Vicky Mehto and was sold to Phulmati Devi by virtue of registered deed, and she was put in possession. And her name was also mutated in the revenue records. Vicky Mehto had also sold another property in Khata number 202 through registered sale deed who were in possession of 71 decimal of land. It was also asserted that the genealogy of the plaintiff was incomplete and the plaintiff and the dependent do not constitute joint family property. Joint family. It was also asserted that Vicky Mehto was not the owner or in possession of all the suit land mentioned in Schedule A of the plaint. And the land of Khata number 201 was the self-acquired property of Vicky Mehto. And rather it was stated that none of the property was the ancestral property of Vicky Mehto. It was also asserted that Monsma Kedli, wife of late Ghanshyam Mehto, had sold certain property through registered sale deed dated 17/10/73 to Chotilal Yadav and Kameshwar Yadav, and Vicky Mehto had paid the consideration amount on behalf of Kameshwar Yadav, who is the grandson of Vicky Mehto. It was further asserted that the plaintiff Kameshwar Yadav had no male issue, he had only one daughter. And had no earning, and he was being maintained by the dependent Vishu Mehto. Vishu Mehto had also performed the Shraddh ceremony of Lekhu Mehto, who was the father of the plaintiff, Kameshwar Yadav. And the plaintiff was living in a different village, namely village Usmai, and thereafter he went to Calcutta for living. It was further asserted that the plaintiff demanded partition in the year 1980 with respect to land falling under Khata number 41 and 36 of village Usmai and Khata number 201 of village Devipur, on which Vicky Mehto partitioned the land, and the land of Khata number 36 and 41 of village Kusmai was allotted in the share of the plaintiff, and the other land of village Devipur bearing Khata number 201 was allotted in the share of Vishu Yadav. The partition was held in presence of the family members of Vishu Yadav and Kameshwar Yadav. The land of village Kusmai was valuable, so the plaintiff gladly accepted it, and both parties came in possession of their allotted share. Thereafter, a memorandum of partition was prepared in the year 1983. It was asserted that Lekhu Mehto, father of the plaintiff, died in the year 1966-67. Vicky Mehto also died in the year 1982. During the pendency of the suit, the defendant number 1, Vishu Mehto, expired, and his wife, Fulmati Devi, appeared and adopted the written statement filed by Vishu Mehto, and also filed written statement on her behalf. The learned trial court framed the following issues for consideration. Both the parties led joint the oral and documentary evidences before the court. The exhibit G, which is the bone of contention as raised by the learned counsel for the appellant during the course of hearing, was the memorandum of partition said to have been prepared on 15th March 1983. The learned trial court considered the issue number 5 and 6 together. Which essentially related as to whether there was unity of title or unity of possession between the amongst the parties with respect to the suit property. The learned trial court, after considering the materials on record and also discussing the memorandum of partition which was brought for the first time after the death of defendant number 1, has ultimately held that there was no partition in the year 1980, nor the memorandum of partition was prepared in the year 1983. And held that there was unity of title and unity of possession with respect to the suit property except the land which was already sold by DT method. The findings of the learned trial court, the ultimate findings of the learned trial court in connection with the memorandum of partition and the partition of the year 1980 and memorandum of partition of the year 1983 within bracket exhibit G has been recorded in paragraph 18 of the trial court's judgment, which is as under. So far as the learned first appellate court is concerned, a detailed discussion has been made in paragraph 27 in connection with the memorandum of partition dated 15/1/1983. The discussion is quoted as under. This court finds that both the learned courts have taken into consideration the memorandum of partition exhibit G and have cited sound reasons for coming to a conclusion that no reliance could be placed on the memorandum of partition exhibit G. Further, the learned court has also taken into consideration that barring the has also taken into consideration in paragraph 28 of the appellate court's judgment that barring the rent receipt with respect to the property which was sold in favor of the wife of original defendant number 1, no document regarding possession of the defendants over rest of the land of the suit land was filed. It was also recorded that it was an admitted fact that the parties were separated in mess and residence, and the plaintiff had pleaded that the parties were cultivating as per their convenience. The other materials on record, placed on record, were also taken into consideration by the learned first appellate court, and ultimately it was held that there was no previous partition, and the learned first appellate court has ultimately upheld the judgment passed by the learned trial court and dismissed the appeal. Upon going through the judgments of both the courts, this court is of the view that there is no perversity in the matter of appreciation of materials on record while coming to a finding that there was no previous partition. This court also finds that the learned courts have not committed any perversity while appreciating the Exhibit G, which was just one of the material for consideration with respect to the previous partition. This court finds no merit in this appeal, which is here dismissed.
Sir. Parcel of case item 32, second appeal 216 of 2018.
This second appeal has been filed by the defendant, respondent, appellant against the judgment and decision of reversal.
So before we have to take care of order dated 6th of November 25.
Order?
6th of November 25. Whether the appellate court's judgment and decree would survive on account of the fact that pro forma respondents had expired during the pendency of the title.
6/11/2025,
Yes.
IA for substitution of respondent 3, 5 and 6 was allowed.
That was allowed, but
Based on this, that is not the subject to be. Now the question is that this
whether the appeal is maintainable or not.
now.
Many
So far
persons,
this appeal, the lordship mechanism in this context, my humble submission before the lordship would be that the plaintiff lost this suit. Now the plaintiff as an appellant preferred the appeal, title appeal. Now during the pendency of that appeal, title appeal, which has been decided against the present appellant, now those respondents died. During the pendency of the appeal, before filing this second appeal.
yes,
So, the question has rightly recorded in the last order. That if then the appellate degree is against a dead person, so it will be a nullity, practically.
yes.
So if it is held nullity, then why I shall pursue the second appeal?
No, then there is the matter will, the liberty will still be there. Because if you don't want to pursue the second appeal, then the trial court decree will become final.
The trial court degree is in favor of the
The
appellant.
appellate, no.
Appellant. Trial court degree is in favor of the appellant.
So therefore, the matter has to be re-agitated before the learned first appellate court. You just can't win a case like that.
There are judgments of the Honorable Supreme Court followed by the Honorable
Yes.
the coordinate bench that when a decree has been passed against a dead person, so it becomes nullity.
So,
If the appellate court judgment is nullity, because in suit where I succeeded, they were alive. Now that judgment has been assailed by the respondents here in appeal, civil appeal. And that civil appeal, during the pendency of the civil appeal, They were the appellants and we were the respondents. And two of the respondents died during the pendency of the appeal. It was for them to get those respondents to be substituted. They did not take any step for substitution. Thereafter, Lord, this second appeal.
The plaintiffs did not take any steps for substitution of one of the contesting defendant,
Yes.
who was Bashir Mia,
Yes.
and two pro forma defendants,
Pro forma
Juman
defendant.
Mia and Munna Mia.
Ultimately, they were also the
The
defendant.
Juman Mia and Muslim Mia.
Now, Bhutta,
So notice have been issued to them also.
yes.
Where are they? If they are not there, I will say that it's a nullity. It will be open to them to approach the appellate court for
One of
fresh
the
judgment.
as per the list, Lord, I find
Yes.
name of one of the counsel Lord is there.
बताइए कौन है? लिस्ट में बताइए किसका नाम?
Excellent. Yes. Ankit Burman, Kumar December.
कहाँ है?
Two persons. दोनों का नाम
उनका
है।
वकालतनामा दिखाइए किसकी तरफ से है?
दोनों का नाम फाइल हुआ है। उनका नाम पता है। Plaintiff.
For the respondent number 1, 2 and 4.
They are the plaintiffs.
1, 2 and 4 are the plaintiffs.
Yes. 1, 2 and
1, 2
and 4.
and 4. Munna.
1 and 2 are the plaintiffs.
Where are they?
Not familiar.
इसीलिए नोटिस किए थे क्योंकि उनको पता तो चलना चाहिए ना कि उनका जजमेंट सेट असाइड हो.
इसलिए 1 and 2 are the plaintiffs.
1 and 2 are the plaintiffs. They were the appellants before the first appellate court. बुलाइए वे उनके एब्सेंस में ऑर्डर नहीं करना चाहते.
002 प्लस कर दिया जाए.
हाँ नाम फ्लैश कर दीजिए. अंकित बर्मन एंड कुमार विश्वेश्वर. रफीक मियां कौन है? रफीक मियां 1, 2 and 4.
याकूब मियां, रफीक मियां 1 and 2
and मुन्ना मियां.
and मुन्ना मियां who have 4.
बुलाइए. ये वाला बंडल नहीं ब्लैक.
All of the defendants number 2, 3, 2 to 9. Respondent number 2 to 9. कोई स्टेटमेंट में हम लिखे हैं डिस्क्रिप्शन. Defendants number 2 to 9, respondents number 2 to 9. They are the appellants. जजमेंट है जिसमें महिला जो तो जजमेंट है तो जिसमें कहा है कि
You see, when it is a nullity, then under such circumstances,
the appellate court judgment will go. Then your lordship may also consider this aspect that due to technicality, if it goes, then whether it will be proper to remit the matter back to the appellate court at that stage. Now, a right which has been accrued to the appellants, present appellants, due to non-substitution and this appeal abated. In an abated appeal, the decree was passed against the dead persons. They were also the defendants. To be proper, not to hear them also in this aspect. Lordship may kindly see the decree in appeal. I have filed it, Lord. Yaqub Mia and Rafiq Mia were the plaintiffs' appellants.
देखिए आपके लिए एक ऑर्डर लेके आए हैं, कोऑर्डिनेट बेंच का ऑर्डर है, इसी तरह से ऑर्डर
जी
that the second appeal itself is not maintainable, but still it is open to the appellant before the first appellate court to get the
That is-
reopen the matter.
yes. Refer to a Supreme Court judgment also. Yes, I have seen it. That is the reason on that I was.
Where are they? बोलो तो आई ना.
कौन करेगा?
Are you there in this case?
In this case, there is a difference. In fact, the appearance before this honorable court were the appearance in the court below.
Yes.
That is the only difference. And that basic difference will change the scenario. Because here, the appellants were the appearance in the court below. That is their fault. They could not get them substituted. And that is the reason this honorable court said the learned counsel for the appearance submits that the appearance will approach the first appellate court for impleading the legal representatives of the
Now
deceased.
here the respondents will approach the first appellate court for
This,
implementation.
that is the reason. This is
यही फर्क होगा.
This is the basic difference.
Now we will pass an order that the respondent plaintiffs will approach the first appellate court,
Before the first appellate court.
right?
By taking
Because
recourse to law.
none of there were 3 respondents in the first appeal. It was not brought to the notice. Maybe 2 of them were full brothers.
Full brothers. In fact, not
They were full brothers.
They are the original plaintiff was sister of the defendants. Original plaintiff. She died. She was substituted by the present plaintiffs, not of the respondents. Number 1 and 2. They are sons of original plaintiff. And the defendants, your lordship may kindly see only one line from the appellate court judgment. I will just so what is their relation? Your lordship may kindly see from the appellate court judgment.
Yes, I am seeing the appellate court judgment.
Yes, your lordship just see the relevant part.
You just see the cause title.
Yes. Appellate court.
One and appellant number 1 and 2 before the appellate court were sons of late Ramzan Mia.
They are coming through their mother.
Maybe,
His
but
mother.
they are all sons of Ramzan Mia.
Yes.
Correct.
Yes.
And the pro forma respondents number 1, 2 and 3. They are also sons of Ramzan Mia.
For former respondents, नहीं 1 to 2 to 9 they are not.
2 to 9 तो आप लोग हैं.
हम लोग हो गए.
1 to 3. Pro forma respondents number 1 to 3.
1 to yes.
Bottom में.
They are Ramzan.
Jumman Mia died. Muslim Mia died.
Yes.
So full brothers of the appellants they died.
Appellant. Yes. Original
And 2
appellant.
full brothers. And 1 Bashir Mia died.
Yes.
Bashir Mia died in 2008, who was not substituted.
In the
Correct.
appeal. While the appeal was pending.
While the appeal was pending.
Yes.
He was not substituted.
Appeal was filed in 2007.
Yes.
Title appeal
But he was not
118 by
substituted.
2007.
He was not substituted. So
So in this suit they were allowed.
the appeal was allowed while keeping one of the contesting defendant who was already dead
Yes. So this is against the dead person.
against a dead person.
Dead person.
And
If I forget about the form of party.
Yes, counsel.
Lordship, arguing counsel, father is hospitalized. Lordship, praying for
Who
2
is
weeks.
the arguing counsel?
Ankit Barma, Lordship. Respondents, from respondents.
He is in hospital since when?
Lordship, if I am not wrong, 1 week. His father is hospitalized, is in critical condition.
That's right.
So, right now I got the instruction. Sorry, Lordship.
You have not been appearing before this court on repeated occasions, right? 5 डेट हो चुका है. 5 डेट से पिताजी हॉस्पिटल में.
Lordship,
Yes.
Lordship, I don't have that information.
You will not have that information. Where is the other counsel? एक के पिताजी हॉस्पिटल में. Where is the other counsel?
Lordship, I have to take instruction.
He is just only name lender in the Vakalatnama. बताइए
My apologies.
उनको बुला के देखिए जो भी दूसरे काउंसिल ठीक है अंकित वर्मा के और ये कुमार विश्वेश्वर
पहचानते नहीं पता I know Ankit Verma, Lordship.
देखिए ऐसे नंबर 216 of 2018 सबसे कोर्ट में नहीं आ रहे हैं अंकित वर्मा
Lordship,
आज कोर्ट में नहीं आए हैं
नहीं, he is in Durgapur, Lordship. उनके father critical मतलब condition है. इतने I have this information. If I am not wrong, 2 weeks से तो appear नहीं हो रहा. हम नहीं देखा भाई तो.
Learned counsel for the appellant is present. It has been pointed out by the learned counsel for the appellant by referring to the cause title of the first appellate court that Bashir Mia, who was respondent number 1 before the first appellate court,
Performance.
he is not pro forma respondent. He is
Obviously,
contesting
yes,
respondent.
he is.
Who was respondent number,
Yes.
who was contesting respondent number 1 before the first appellate court, and 2 pro forma respondents, namely Jumman Mia and Muslim Mia, expired on 16/3/2008, 2008 and 3/11/2008 during the pendency of the title appeal. He submits that the first appeal was allowed and the contesting defendant number 2 to 9 of the first appellate court are the appellants before this court. He has also submitted that notices were also issued to the legal heirs of Bashir Mia, Juman Mia and Muslim Mia, but they have not entered appearance in spite of service of notice. The learned counsel submits that since the appeal was decided against dead person, including appeal was decided while one of the contesting defendant had one of the contesting respondent Bashir Mia had expired. Therefore, the appellate court judgment and decree is a nullity. He has referred to the order passed by this court dated 21/6/2023, passed in second appeal number 134 of 2019, and has submitted that the only difference in the same case and the present case is that here the appellate court, the appeal was allowed and the respondents before the appellate court are the appellants before this court, and consequently at best it can be kept open to the appellants of the first appellate court to get the
Take appropriate steps.
to take appropriate steps before the first appellate court. यही होगा
Yes.
मिस्टर नाम बताइए
Zaid Ahmed, Lordship.
Mr. Zaid Ahmed submits that the arguing counsel
Ankit Verma.
Mr. Ankit Verma
Verma.
is not available as his father is in critical condition
Critical and Lordship.
at Durgapur
Yes, Lordship.
and he has not been attending the court for a few days. The learned counsel submits that the matter be posted on
After 2 weeks, no, Lordship.
be posted after 2 weeks on 27 January. Post on 27 January.
The interim order should continue. The
Interim order passed earlier.
11/9/2020.
जो भी है उसको इंट्रीम ऑर्डर कंटिन्यू करके इसलिए लिखा दिया, हमको बोलिएगा ये ऑर्डर निकाल के पढ़ लेंगे, ठीक है।
Item 34, 2nd April 478 of 2018.
Yes, Appilan?
I would like to submit a prior apologies. मैं कभी आपकी कोर्ट में अपीयर नहीं हूँ, शायद कुछ हो जाए। सेकेंड अपील में मैं कभी अपीयर नहीं हूँ, मैं आज करती हूँ। वर्षिप ये पार्टीशन सूट इनिशिएट हुआ था, मैंने किया था इंटायर प्रॉपर्टी की पार्टीशन के लिए 11.79 एकर्स ऑफ लैंड के पार्टीशन के लिए मैंने पार्टीशन सूट फाइल किया था वर्षिप। लेकिन लोअर कोर्ट ने केवल 2 इशू को डिसाइड कर दिया और बाकी प्रॉपर्टी छोड़ दिया। उसमें लोअर कोर्ट ने किया कि ये पार्टीशन हुआ है कि नहीं हुआ है, तो कौन से प्रॉपर्टी का पार्टीशन हुआ है कि नहीं हुआ है, तो प्लॉट नंबर खाता नंबर 75 का पार्टीशन हुआ है ऐसे डिसाइड किया। और जो ट्रांसफर हुआ है, सेल हुआ है प्रॉपर्टी का 30 डिसमिल ऑफ लैंड उसमें ट्रांसफर हुआ है लॉजिक। तो कोर्ट ने लोअर कोर्ट बिलो और अपीलेट कोर्ट में जिन्होंने डिसाइड किया कि और 2 इशू को कि वो पार्टीशन उस स्पेसिफिक प्रॉपर्टी के लिए पार्टीशन हुआ है, पार्टीशन एग्रीमेंट हुआ है कि नहीं हुआ है, और जो ट्रांसफर डीड है नंबर 705 वो वैलिड है कि नहीं, उतना को ही केवल डिसाइड किया। लेकिन मैं पार्टीशन सूट के लिए आई थी, इनिशिएट हुआ था इंटायर शेड्यूल ए और बी के पार्टीशन के लिए लॉजिक। तो लोअर कोर्ट ने उस चीज को छोड़ दिया। मेरा इसमें क्लियर है कि इंटायर प्रॉपर्टी को कंसीडर करना था, पार्टीशन करना था। जबकि एडमिटेड ही है प्रॉपर्टी, टोटल प्रॉपर्टी जो है लॉजिक वो जॉइंट है, दोनों पार्टी ने एडमिट किया है और कोर्ट की फाइंडिंग में भी आया है कि जॉइंट प्रॉपर्टी है।
No, it was not just a partition suit. You had also filed for a declaration that the sale deed is null and void. There are so many prayers made. That was not the only relief.
No, प्रेयर मेरा 3 इसमें प्रेयर था। पहला प्रेयर था मेरा पार्टीशन के लिए लॉजिक, दूसरा प्रेयर था इसमें ये जो सेल डीड बना था उसको करने के लिए प्रेयर था। और वो जो रिलीफ मैंने पहली जो रिलीफ क्लेम किया था वो पढ़ूंगा।
तो पढ़ ली।
मेरा प्रेयर था लॉजिक, मेरे डीपी मैंने पास partitioning the suit property giving half the share of the plaintiff and their share be carved out by appointment of survey knowing advocate, and after passing the final decree the plaintiff be put in possession of their share by process of the court. लॉर्डशिप अभी जो प्रॉपर्टी उन्होंने सेल किया वो ऐसे सेल किया कि मैं लैंडलॉक हो गई। मेरे आगे से जो रोड था वो पूरा रोड साइड फेसिंग प्रॉपर्टी लैंड को सेल आउट कर दिया।
अब पढ़िए पैरा 14।
मेरे प्लेट
फाइनल पार्टीशन सूट का इंटरनल पेज 8।
पैराग्राफ नंबर 14 पढ़ूंगा।
यस,
दैट्स व्हाट
पहले इश्यूज पढ़िए,
जी
पहले इश्यूज पढ़िए, इश्यूज पढ़िए।
फर्स्ट अपील का वर्षिप
पैरा नंबर 4। of the trial court judgment.
Trial court का तो the खाता number
नहीं, trial court judgment para number 4, internal page 3.
मेरे पास जजमेंट नहीं है लॉर्डशिप, इस उससे आया है मेरे पास, एनओसी से आया है और केवल एक ये है मुझे सेक्रेटरी ऑफ इनकम मेमो कॉपी। अगर एक वीक भी टाइम देंगे तो मैं कोर्ट से
1 मिनट का टाइम दे देंगे।
लोग कोर्ट के डिग्री का कॉपी नहीं मेरे पास नहीं है।
बिना फाइल के, बिना इसके, ये कौन सा ट्रेनिंग है आपका? ये किस तरह का ट्रेनिंग है? बिना इम्प्यून ऑर्डर के खड़े हो गए बहस करने सेकेंड अपील, और ये बोल के कि हम पहली बार केस बहस कर रहे हैं।
जी मेरे
जो ऑर्डर जजमेंट के भी कितना दिन हो गया प्रैक्टिस करते हो? 2 साल। आपको ये नहीं पता कि इम्प्यून ऑर्डर की कॉपी की जरूरत पड़ती है? अच्छा, आप ट्रायल कोर्ट का जजमेंट नहीं दिया?
नहीं है
नॉट रिक्वायर्ड टू रिसीव।
रिक्वायर्ड टू रिसीव लॉर्डशिप, मेरे पास एनओसी आया है तो ये आधा कॉपी।
इनको ये फाइल दे दो, आप पढ़िए बैठ के, पौन घंटा पढ़िए तब आपको सुनेंगे। 4:25 से सुनेंगे, ठीक है? चलिए इनको फाइल ही दे दीजिए। आपके लिए मार्क भी करनी है।
Item 35, second appeal 525 of 2018.
आज सबके यहाँ सब कोई ना कोई मर ही गया है क्या? मतलब आई एम सीइंग सुबह से ही सुन रहे। अभी क्रिमेशन में क्या है? बताइए कब रखते हो?
कोई भी डेट कल
पिछला कई डेट से तो 2023 से ही चल रहा है लास्ट चांस। 2023 में लास्ट चांस हुआ, उसके बाद 1,000 रुपये फाइन लगा 22/7/2024 को, उसके बाद 30/9/2024 को 2,000 रुपये फाइन लगा, फिर आज जो है लगभग 1.5 साल बाद केस लिस्ट।
कल
किसी के डेथ के टर्म में तो हम टाइम देंगे, टाइम आई विल नॉट रिफ्यूज। लिखिए काउंसिल फॉर द अपीलेंट, नाम बताइए इनका नाम लिखिए। Seeks adjournment by saying that there has been bereavement in the family of the Agri Council Mr.
संदीप
Sandeep Verma. However, the office note reveals that notice upon respond number 1, 3 and 23 has neither been served nor they have appeared by filing a file. Counsel for the appellant is permitted, at this, the counsel for the appellant has raised for and is allowed time till ninth of February to take fresh steps for service of notice upon respondent number 1, 2 and 23 at their present and correct address, or to take appropriate steps for substituted service of notice preemptive.
Okay.
Speed post से होगा है ना? Post this case on 23rd of February.
Item 36, second bill 138 of 2019.
Yes, Mr. Mehta, how are you?
Yes.
Seeing you after a long time.
Yes. I am good. Yes, now this appeal is under section 86(2) of the CAT Act. It's not against a decree, or not against under section 100. It's in 86.
अभी तक एक साल हो गया है तब हमको समझ में आ गया 86, 87 का.
Yes.
It is an appeal under section 87.
Sorry, not 86, 87 too. 87 one is lies before the district judge, 87 two before this court. So I am defendant number 2 in the suit. The appeal is by the defendant number 2. Now plaintiff instituted a suit for making necessary corrections in the record of rights, because this chapter deals with record of rights, and the suit has been declared against. I am defendant number 2. Defendant number 1 is the state. Plaintiff number 1 and plaintiff number 2 say that they had purchased lands through 3 sale deeds of the year 2004, 6 and 8. After purchasing these lands, the lands were also mutated in their names, but on account of the new record of rights, preparation of new record of rights, their names have not been recorded. The name of Jharkhand Sarkar, the Anabad Jharkhand Sarkar has been recorded. So that is the
Jharkhand Sarkar has been recorded with respect to the entire suit property.
this is suit property 75 decibels.
That's right.
Yes,
Part is recorded in the name of Jharkhand Sarkar and
Yes.
part in the name of
Yes.
respondent number 2.
No, not in the name of respondent.
Why is respondent number 2 coming?
Respondent number 2, they filed this application saying that they are claiming title over this land. In fact, we are in possession. It is our case that the lands are have vested under the provisions of the Nationalization Act, and therefore they say our name should be corrected, and they knew that we are in possession. But anyhow, this suit was instituted and the suit has been decreed in their favor, saying that since the lands have been recorded, since the lands have been purchased by virtue of sale deeds and the lands have been mutated, so therefore the name of the plaintiff should be recorded in the record of rights. Now against that we have preferred an appeal. My appeal has been dismissed, saying that rightfully it has been recorded because their names have already been mutated by virtue of the sale deeds. Now, during course of hearing before the appellate court and before the revenue officer, we had produced certain maps also, showing mining plans showing that mining work has been carried out in that piece of land. The appellate court has noted this fact, but there is no finding to that effect. So this is in sum and substance the case now.
Possession something, you know. So what is the question?
There won't be any question of law in this. Had it been a substantial.
There has to be a question of law, if not a substantial question.
Yes. A question of
Unless
issue.
there is a question,
Issue.
So in these cases, I am just terming it as a question of law instead of writing
Yes,
it
yes.
as a substantial question
Yes,
of law.
yes.
That terminology
would
is
be-
not being used.
Yes.
But
It
there
would
has
be
to
an
be a
issue.
question of law.
The question of law would be whether the courts below have erred in not recording any finding with regards to the possession of the defendant number 2. My possession is, I'll show only those portions now. Kindly turn to firstly page 23.
You see, it is essentially a matter of rectification of record of rights.
Yes.
Record of rights does not record title.
True. There's no problem on that.
Yes.
There is no problem on that. Still, because this chapter of the
And
CMT
you
Act.
did not file your petition for rectification of record of rights.
Me?
Yes.
No, we did
It
not
was
file.
not your petition.
No,
It
I
was a
did.
petition of the plaintiffs.
Plaintiffs.
They wanted certain entry in the record of rights.
Yes.
And in the record of rights, your name was also entered.
No.
Then, but you claimed possession.
We are claiming
If
possession.
you are claiming possession, you should have filed your independent petition seeking rectification of record of right. It is not your case.
No, it is not.
If it is not your case, then how in the case of a plaintiff you will get a relief that you are in possession of?
No, I'm not. I am solely saying that while determining this finding by both the courts, they should have considered this aspect of the matter relating to possession. Because the law is like that. I'll just show to you. Otherwise also, otherwise, it is true. The Lordship has pointed out title. One of the reasons for dismissing my appeal is that I have already instituted a suit.
At least
That is also there.
if you have already instituted a suit, there are intricate question of title, right, title, interest in possession. So that will be taken care of in the suit.
That can be. I'll show that portion. Kindly see firstly page 23, madam. I just wanted to show that.
Yes.
If,
Let us see first the trial court's order.
yes, ma'am. Starts from page 12. There are two prativadis. Page 12 records. First is Anabad, Jharkhand Sarkar, Dwara Anchaladhikari Nirsa is the defendant number 1. And I am Purvi Koila Kshetra Limited is defendant number 2. Now here, the Mantavya, that is findings, is at page 14. Bottom.
Page 14.
Page 14 bottom.
Yes.
सभी तथ्यों प्रमाण तथा गवाहों के बयान एवं अंचल प्रतिवेदन के अवलोकन से स्पष्ट होता है कि विवादित संपत्ति वादी की क्रय संपत्ति है, जिसका क्रय दलील का विधिवत दाखिल खारिज होकर वादी के नाम कायम हो जमाबंदी कायम हो चुका है तथा शुद्धि पत्र करेक्शन स्लिप भी निर्गत है। वादी के विवादित संपत्ति का लगान भी सरकार को भुगतान किया जा रहा है। वादी के द्वारा दाखिल साबिक खतियान के अवलोकन से स्पष्ट होता है कि वादी का दावा रैयती खाते की संपत्ति पर है। अंचल प्रतिवेदन में भी अंचल अधिकारी द्वारा स्पष्ट कर दिया गया है कि वादी के दलील का दाखिल खारिज होकर वादी के नाम से जमाबंदी कायम हो चुका है, जो अद्यतन कायम है तथा विवादित साबिक खाता नंबर 5 रैयती खाते की एराजी है। इससे वादी का दावा एवं प्रमाण सही एवं सत्य प्रतीत होता है। विवादित संपत्ति के प्रतिवादी के द्वारा भी ऐसा कोई भी प्रमाण प्रस्तुत नहीं किया गया है जिससे स्पष्ट हो सके कि यह संपत्ति पूर्व कोयला क्षेत्र की संपत्ति हो। उक्त प्रतिवादी ने खाना 2 के सुधार के लिए भी कोई दावा नहीं किया है। The Lordship rightly pointed out this that I have not made any claim. तथा विवादित जमीन का किस्म भी खदान नहीं है। उक्त प्रतिवादी ने यह भी स्पष्ट नहीं किया है कि यदि यह संपत्ति व्यस्त हो चुकी है तो किस रैयत को इसका मुआवजा दिया गया। इससे प्रतिवादी का प्रतिदावा आधारहीन प्रतीत होता है। अतः विचारोपरांत वादी का दावा प्रमाण एवं अंचल प्रतिवेदन के आधार पर सत्य एवं सही प्रतीत होने का कारण स्वीकार किया जाता है। अतः आदेश दिया जाता है कि मौजा भोपाल प्रतिवादी अनावाद सरकार का नाम विलोपित कैंसिल समझा जाए तथा दखल खाना से पूर्व कोयला क्षेत्र के नाम इन द रिमार्क्स कॉलम पोजीशन कॉलम आवर इनपुट दखल खाना से पूर्वी कोयला क्षेत्र का नाम एवं अवैध दखल विलोपित समझा जाए एवं उक्त भूखंड का सुधार खाता आदि जगन्नाथ माझी विकास उत्सव। So this is the findings of the revenue officer Rajaswa Padadhikari Dhanbad. Then comes the appeal bill. And here findings would start at page 20, paragraph 7. Is ready? Page 20.
Yes.
Yes. Findings. Parasaran. The learned counsel for the apparent defendant number 2 has submitted that the impugned order passed by the court below is not correct. I'll skip this.
Yes.
Page 21 top. He has further argued that court below has not considered the fact that plot in question was in effective possession of the Eastern Coalfields Limited and gave erroneous finding to that effect. The court below has not considered the provisions of the Nationalization Act. The learned court below has wrongly relied upon sale deeds and receipts, which were sham and collusive documents. Hence, it is. These were the 3 points that I raised. Then, at the bottom of this page, reference is coming of the suit that I have instituted.
Can you
Last 3 lines.
You read this.
Yes.
The learned counsel appearing
Okay.
for the respondent.
Yes. The learned counsel appearing for the respondent number 1 and 2. Plaintiffs supported the impugned order. He has submitted that word commissioner and judicial.
These are all technical.
They will forget this. They'll come down gradually.
It is further argument of the appellant that
Yes.
is suppress the fact.
Yes. It is further argument that appellant has suppressed the fact that material fact that appellant has already filed title suit number 124 of 2017 against the respondent Jagannath Maji and Jitu Park during pendency of this appeal, in which they have made a prayer for recovery of past possession by demolishing the structure found to have been constructed by the respondent. And in this case, the Eastern Coalfield Limited has also made prayer for injunction, which was rejected by the court below by the order dated 18/9/17. The relevant document, now this is one fact, and this goes on, my lord. Can I read
So
paragraph 8?
therefore you cannot say that you are in possession.
No, no, you are.
You see,
Yes, yes.
that once you file a title suit seeking recovery of possession,
And also seeking injunction.
injunction
Injunction has been refused.
refused.
But this
But you
part
are
of the,
seeking recovery of possession also.
yes, sir. No,
See-
confirmation of
No. They
And
made a
this is-
prayer for recovery of past possession by demolishing the structure. You wanted that structure by saying that it might have been, acquired, it is a part of the acquisition of land. Once you are seeking recovery of possession, then how your possession can be said?
Kindly see page 24, the middle portion of this first paragraph. It starts by saying Xerox copy of Xerox copy of certified copy of order dated 18/9/17. Passed in original suit number 74 has been filed. The user of these documents shows that Mr. Eastern Coalfield Limited has instituted title suit against Jagannath Manji and Jitu Pal with respect to the land in question for declaration of title and confirmation of possession and injunction, and by the order dated 18/9/17 the court will has rejected the prayer made by the Eastern Court Limited. Now, based on this, my appeal is being dismissed. You should see this question. That since I have already instituted a suit, it's true that I have filed a suit for declaration of title.
You see,
So
under
that
the
was-
provision of section 87 itself, first proviso. Under the provision of section 87 itself,
Provided also that in any suit under this section, the revenue officer shall not try any issue which has been or is already directly and substantially the issue between the same parties or between parties under whom they or any of them claim in proceedings for the settlement of rent under this chapter, where such an issue has been tried and decided or is already being tried by a revenue officer, leaving apart from this also, otherwise
that
also,
will be decided in as per law. So,
because I have already instituted a suit
yes.
for declaration of title, and so that is a superior title which I
That's
will
right.
ultimately, if I succeed, I get.
And it has got nothing to do, after all the rectification of record of rights, that declaration will follow the rectification of record of rights automatically. It is
In
between
case
the
I
same
succeed,
parties.
the order would be passed to correct the record of rights.
That's right. Okay. Second appeal number 138 of 2019. Heard the learned counsel appealing on behalf of the appellant. This appeal has been filed under section 87 during that 2.
Respondent Jitu Pal.
आपको notice हुआ था?
Notice was. Impression.
So the title will be decided in the title suit, isn't it?
So,
Title, possession, everything will be
so in this
decided.
connection, both the courts will have rightly decided the proceeding and the.
Heard the learned counsel for the. We are only Jitu Pal
Jitu Pal.
और जगन्नाथ माली नहीं है.
appear किया है.
तो प्रॉक्सी चल रहा आपका?
No, अपने लिए.
आप सिर्फ अपने लिए है ना? ठीक है. Heard the learned counsel for the appellant. Counsel for the respondent number 2, Jitu Pal is present. State. Nobody appears on behalf of respondent number 1, Jagannath Mali, and respondent number 3, the state of Jharkhand. This appeal has been filed against the judgment dated 16/7/2018, passed by the learned Principal District Judge Dhanbad in Civil Miscellaneous Appeal number 32 of 2016, whereby the learned First Appellate Court has affirmed the order dated 26/9/2013, passed by the learned Settlement Officer Dhanbad in case number 313 of 2010. And the learned counsel for the appellant has submitted that the learned First Appellate Court has failed to consider that the present appellant is in possession of the suit property. He has submitted that in the record of right, illegal possession of
Yes.
the present appellant has
Yes,
already been recorded.
Appellant is defendant number 2.
The present appellant was defendant number 2 in the case.
And one thing, kindly see page 23 minutes. There is a map of the colliery where paragraph 23, fourth line from the top.
Paragraph 23.
Page 23, not paragraph, page 23. Page 7 of the appellate court judgment. On behalf of the appellant, defendant, map of Lakshmi Mata Colliery has been filed in order to show that the land in question is in their possession. This is only one thing.
That has not been exhibited as such.
In courts, revenue courts, they don't mark them as exhibits.
They mark exhibits.
They haven't marked any document.
They mark exhibits. The learned counsel has also submitted that before the learned First Appellate Court a map of the Lakhi Mata colliery was filed to show that the land in question was in the possession of the appellant. He has submitted that this aspect of the matter has not been properly considered. However, from the perusal of the order passed by the learned revenue officer, it does not appear that the map was produced by the present appellant before the state authority. ऐसा तो नहीं लिखा है कहीं भी।
कोई डॉक्यूमेंट का भी इन्होंने ये नहीं किया है कि दिस इज नॉट एग्जिबिट
नहीं है प्रतिवेदन पत्र है खाली। अच्छा एनीवेज ये लास्ट सेंटेंस मत लिखिए।
यस बोलो
यस ये कुछ लेटर से आपने कुछ फाइल कर दिया
जी, क्योंकि इनका भी देयर आर रेफरेंस ऑफ नंबर ऑफ डॉक्यूमेंट्स, ये रसीद फाइल किया, ये किया, बट उसका कोई एग्जिबिट कहीं की चर्चा नहीं, देयर इज नो मेंशन।
After hearing the learned counsel for the appellant, this court finds that Jagannath Manji and DT.12.01.2026 had filed petition seeking rectification of record of rights, wherein the property was recorded in the name of state of Jharkhand
Yes.
and was shown in the possession of the present appellant. The plaintiffs claimed the suit property by virtue of three registered sale deeds of the year 2004, 2006 and 2008, and they also claimed that the mutation was also carried out in their name
Rent receipts
and
were issued.
rent receipts were also issued and Jamabandi was already created in their name. The defendants in the suit oppose the prayer. However, the learned revenue officer, by referring to the documents produced by the plaintiffs, recorded that the property is the realty property of the plaintiffs, and also recorded that the defendant number 2 could not produce any document to show that the property is falling within the
Is the vested? Is the vested property?
yes, the property belongs to the defendant number 2. And that any rayat has, and the rayat has been paid compensation for the property. Consequently, the revenue officer directed that the name of the state of Jharkhand be deleted from the record of rights, and also directed that the illegal possession of the defendant number 2 be also deleted. Consequently, agreed with the order, the state of Jharkhand did not prefer any appeal. However,
Defendant number
the
2.
defendant number 2 preferred an appeal.
Civil miscellaneous.
Which has been decided, which was numbered as Civil Miscellaneous Appeal number 32 of 2016. From the perusal of the said order, said impugn judgment, it appears that the specific case of the defendant number 2 before the first appellate court was that the land in question was in effective possession of the defendant number 2, and the learned revenue officer had not considered the provisions of the Coal Nationalization Act of 1973.
Should be coal mines.
Coal Mines Nationalization Act 1973, and the court has wrongly relied upon the sale deed and the rent receipts, which were alleged to be sham and collusive documents. However, the learned court recorded that the defendant number 2 / the appellant had suppressed the fact that the appellant had already instituted a title suit number 124 of 2017 against Jagannath, Mali and Ritu Pal during the pendency of the appeal, and wherein the appellant had claimed declaration of the title and confirmation of possession and prayer for injunction was also rejected by the order dated 18/9/2017. The court also recorded that the first appellate court ultimately recorded that long Jamabandi cannot be cancelled unless fraud and misrepresentation has been established while opening the Jamabandi, and also recorded that Jamabandi was already opened in the name of the plaintiffs, which was never cancelled by the state. And ultimately the court recorded that the judgment passed by the learned revenue officer did not suffer from any incorrectness, illegality or impropriety. The fact remains that this court is of the view that admittedly title suit number 124 of 2017 is pending, yet it is pending,
Yes.
is still pending between filed by the present appellant against Jagannath, Mali and Ritu Pal, and the appellants have claimed title over the property,
Yes.
title as well as possession of the property. So far as the impugned judgment is concerned, this court does not find any illegality to interfere with the same. And certainly the pending suit will be decided in accordance with it.
Title
Okay.
suit. हाँ, किस सूट का नंबर था निकाल?
Title suit number 147 of
2017.
2017. This appeal is accordingly dismissed.
Orders BT item 10. First appeal file number 13203 of 2024.
previous. Appellant absent. Appellant absent. Time till 12th of February is granted to the appellant to remove the surviving defects readily. If the defects are removed within time, office is directed to place the case on 18th of April for the
Item 11, first appeal file number 13649 of 2024.
कुछ नहीं जमा करते सेम ऑर्डर उनका भी था फर्स्ट ऑर्डर में भी एब्सेंट था
Item 12, first appeal filing number 327 of 2025.
2 weeks time will be allowed for the segment.
सॉरी
2 weeks time, there is 2 defects and limitation petition and for 1 day and the court fee. Within 2 weeks, I will.
सेम ऑर्डर
Item 13, first appeal filing number 5713 of 2025.
same order. These are all preemptory orders. Provision of law has not been correctly mentioned. इसके लिए तीन हफ्ता चाहिए आपको टाइम.
Item 14, second appeal file number 6332 of 2025.
All the defects have been cured. One defect, but due to oversight, remains which can be cured within a second. The court fees has been deposited by me today. This is the receipt of deposit. The urgency, I have mentioned it. That I have filed an IA number 150 of 2026 because delivery of question will be handed over. 17th coming Saturday is the date.
Filing number SA 6332 of 2025. The counsel for the appellant has submitted that he has removed the surviving defects. Office to check. Post on next Monday.
मैं kindly consider Saturday
आपका पिटीशन डिफेक्टिव रहेगा तो इसमें हम क्या कंसिडर करें? अभी तो कोर्ट फीस का डिफेक्ट है, अभी वो ढेर डिफेक्ट निकालेंगे.
फाइनल रिपोर्टिंग हो गया कोर्ट फीस जमा कर दिए.
हम लोग को नहीं पता, हम लोग को कैसे पता चलेगा? They will check it. उसके बाद आपका मैटर आ जाएगा नेक्स्ट मंडे.
मैं प्रे डे आफ्टर टुमारो.
ना तेजी से तो नहीं हो पाएगा.
Because Saturday is the date for
15 तारीख 15th को पोस्ट. Next call.
Orders item 15, second appeal 40 of 2005.
Leadership on the last day, officer.
Sorry, with my lord's permission, may I remove one surviving defect.
I just not. आपको जो मर्जी हो. आप अभी बोले सारे डिफेक्ट्स रिमूव कर दो. अभी आपका एक सर्वाइविंग डिफेक्ट भी रिमूव.
ऑनरेबल चीफ जस्टिस का नाम मैं थोड़ा सा केवल करेक्शन और
The council is also permitted to remove the surviving defects during the course of the day.
Okay. The records of the titles of the 2 of 1969 we called for later came from the district court of Dumka that it was found here. They tried but the records are not here. And from the Sahibgan the no reply has come. We have already filed a supplementary affidavit that the records regarding the title suit 4 of 1956. That is a substantial question of law regarding the res judicata. Main concern is whatever the records we have already placed before you.
साहिबगंज से भी रिपोर्ट आ गया है. We had called the report from Sahibanj also, no? What is the report from Sahibanj?
No, on the last date, on the issue, providing the order, letter from the Sahibanj, but previously also,
Sahibanj is not responding.
no reply, in the office report, it has said that no reply has came from the court of that.
Issue number 40 of 2005. Raju. Just wait for some. Next. Yes, madam, आपका हो गया? Ready?
पासवर्ड केस आइटम 34 सेकंड पेज 478 of 2018.
Yes, madam. Tell me. You argue in your own manner. अब आप क्या बोलेंगे? आप कौन घंटा आपको दे दिए पढ़ने के लिए? और पढ़ना है?
My case is also the land of khata number 74 and 75 of business Sursa within district Ranchi were recorded in the name of ancestor of the planetary line number 125. Khata number 74 was recorded in the name of Bhikkhu Ganesh and Chamanandi, sons of Subramandi and Sarva, Bhuva and Tepiya, son of the Abhinavandi. Whereas the khata number 75 was recorded in the name of Bhikkhu Ganesh and Chamanandi. इसमें लॉर्डशिप बीगू was dead issueless और गणेश has issues. जम्मू मंदिर के जो इशू थे सुग्रा मंदिर उन्होंने ये प्रॉपर्टी बेचा. There was not any partition by max and bond relating to the land of supposed khatas between the plaintiff and the defendant number 1 to 5. For the convenience, they are cultivating the same खेती कर रहे थे.
Who are the plaintiffs? Plaintiffs are the son of.
They are the son of.
Plaintiff is the son of Ganesh Mali.
Yes. वो तीन भाई थे उनमें से एक भाई जो इशूलेस बिगू थे इशूलेस थे और तीसरे जो भाई हैं उनका ये दूसरे नंबर के भाई हैं गणेश मल्ली जिनके बेटे हैं ये पर्दे और चंद्रू
I'm just putting this matter tomorrow. I'll find out from the RG what happened and why they are not responding. Saipan को letter तो गया है November.
Earlier they had replied to the letter.
Earlier they had replied, and now
the
they are
records
not.
We weren't able to find the records of the letter.
Saipan were not able to find out the records.
But the regard to the previous order that we issued, regarding that they have.
They have not responded, no? So they are bound to respond pursuant to that also, right? So कल रखें, and then we'll pass an appropriate order. सुबह ही आएंगे आप, सुबह ही करेंगे. Other side is there at 10:30 कर दीजिएगा इसको, ठीक है? Counsel for the appellant is present. Close this case at 10:30. Yes, please. You guys now will hear you tomorrow. It's already 4:30. कल आ जाइए.